on my lawyer friend's commentary that seems to outlay what Wizards of the Coast's argument would be. Bollywig says, you are correct in terms of resolving ambiguity in favor of the one not drafting, but there is no contractual ambiguity to resolve here. It's a revocable contract license. The only question is, at what point does it become revocable? Has the reasonable time elapsed given the nature of the license? Now, now here is something completely new, right? Which we have not brought up yet. So there's layer upon layer on layer here. Bullywig says, the only question is at what point does it become revocable? E.g., has a reasonable time elapsed given the nature of the license? And what reasonable notice must be given before termination revocation takes effect? Both these questions are fact-specific and for courts to decide. Edit. If I'd watched a bit further before posting, your lawyer friend says much the same, it seems. Now, that's your lawyer friend being the guy's name. So we have the issue of revocability or irrevocability and authorizing and deauthorizing, and whether or not revocability is inherent or default, or whether that has to be specified. But now, Bullywig is adding something else here and saying, what point does it become revocable? Has a reasonable time elapsed given the nature of the license? Now, I had never heard that. That's the first time that's come up. Can revocability cease after a reasonable time? There's more commentary that's happened on that since I recorded that during the Crafter's Corner, and I want to make sure we have the latest information. So first of all, Bullywig did edit that for a second time, saying, just saw that Ryan Dancy, the architect of the original OGL, has gone on record as saying the intent was to be irrevocable. If true, then that could be found to overcome the presumed revocability nature of this license. All these different levels of things and layers of things to take care of and address. I mean, this is what makes this such a fascinating topic, right? So I wrote back and I said, this is a new wrinkle to all of this. You are the first person I have seen who has brought up the possibility that revocability may cease after some amount of time. Very interesting. Thank you for the insight. Bullywig writes back, thank you, but it's generally the other way around. Typically, a reasonable amount of time must lapse before a license can be revoked. A court would take into account the investment of the licensee, for example, and determine what a reasonable amount of time would be for a said licensee to recoup the investment, make a profit, etc. A court could determine that a reasonable time had not yet lapsed, could never lapse, effectively finding the K irreversible, appearances to the contrary, or have already lapsed. Right? Indeed, for some Ks, the reasonable amount of time could be found to be none at all, meaning they are immediately revocable upon establishment. Once eligible for revocation, then a similar determination would need to be made with regard to what constitutes reasonable notice given the nature of the K, the licensee's reliance on it, etc. Of more interest to me is Ryan Dancy's statement, which is, I think, very interesting as well and goes so much to the original intent, which is why there's a video on it. A K is presumed to be revocable, subject to the proceeding, absent the K specifically saying it is irrevocable. However, Ryan's statement could rebut such a presumption, and a court could find the K to be irrevocable despite its not having so specifically stated. So what do you think? Another layer here. So many things that's going on. So interesting. Let me know what you think down in the comments.